Good evening, everyone. So today we will discuss about last 4 units of business law, that is negotiable instruments, and under which what are those about that. So here it is. So negotiable instruments and its parties. So what happens when any goods are sold by the seller to buyer? So instead of giving cash or money, they are preparing one instrument known as one written document. Okay. So that document, it is signed by the seller to buyer, and it is as a type of receipt or as a type of cash memo. Okay, it is not exactly called as cash memo or receipt, but it is type of that. Okay, where usually what happens, buyer draws a bill. Draws a bill means he or she prepares one bill, and on that it is written that on particular date some contract was made or goods were purchased, and amount of that particular goods, it will be payable after certain day or after certain month. Okay, so after certain month it will be payable by the buyer, and if suppose on that particular date, if suppose buyer is not able to pay, another 3 days of grace is given to them. Okay, so usually this is in case of bills of exchange, but in case of promissory note, what happens here, buyer will make a document or a written paper, that is called promissory note, in which buyer will mention a promise that on a particular date I will promise, or the buyer will promise to pay the amount of money. Okay, amount of, or whatever amount of goods were purchased, that amount will be payable on a particular date. So here bills of exchange is there, and basically bills of exchange and promissory note is given. Okay, and these are actually transferable to one person to another. These negotiable instruments can be transferable, easily transferable, just by merely putting signature on back of the document. Okay, both bills of exchange as well as promissory note, both can be transferred. Or suppose in case of bills of exchange, what happens, if suppose seller needs immediate money. Okay, in an any emergency case, if suppose seller wants money, or whatever amount of money it is written on that document, that is bills of exchange, what the seller will do, or the drawer, okay, the one who will draw the bill, that is drawer, or drawer, he will do, that bill will be taken to the bank. Okay, and drawer will ask the bank that whatever amount it is mentioned in the bills of exchange, please pay to me now, and deduct some charges. Okay, before the bills of exchange is matured. Okay, it will be encashed only after a maturity of date, then only it can be encashed. Before that it cannot be encashed. Okay, it cannot be converted into money. So bank what will do, bank will agree to pay the amount of money, whatever amount is written in bills of exchange, and against that bank will charges some interest. Okay, some percentage it will be charged, and that is known as banker's discount. Okay, so there are certain terms and conditions, and there are certain duties also, rights also, in this negotiable instrument. Okay, so it is discussed in a vast way, so in short I have explained that what is exactly that. Okay, so here as per the Negotiable Instrument Act 1881, instrument is defined as legal document or a legally recognized written paper. Negotiable instrument means a written document which creates a right in favor of some person and which is freely transferable. Okay, which I was telling, it is freely transferable just by putting a signature on the back of the document. Okay, so this can be transferable and it is easy for the payment. Okay, so now again, as per the Negotiable Instrument Act 1881, it deals with only three specific classes of negotiable instrument, which two I was explaining now. So they are promissory note, bills of exchange, check, payable, either to order or to bearer. Okay, check is another negotiable instrument, you can say. You might have seen the format of check. Okay, everybody has seen. So the act does not consider all kinds of instrument which have an element of negotiability in them, such as bills of lading, railway receipt, delivery order on warehouses. So these are some examples which are not taken into consideration as negotiable instrument. Okay, only three of them, that is promissory note, bills of exchange and check. Only these three negotiable instrument can be transferable. Others are not taken into consideration. So don't think that any receipt can be negotiated. Okay, so might be some grocery shops, some receipt, grocery shop has given some receipt and you are thinking about transferring to other. No, not like that. Okay, that is not a bills of exchange. So bills of exchange is a different thing. So as per section 13 of the act, negotiable instrument means a promissory note, bills of exchange or check payable either to order or to bearer. Okay, so fine. It explains that only these three instruments are taken into consideration as negotiable instrument. So then promissory note, what is that? Promissory note, bill of exchange or check is payable to order, which is expressed to be payable or which is expressed to be payable to particular person and does not contain words prohibiting transfer or indicating an intention that it shall not be transferable. So it explains that it is transferable. It is not mentioned that it is not transferable. You can transfer, you can negotiate it. Okay. So here, as I was telling about negotiation, so here a negotiable instrument may be made payable to two or more pays. That means the person who will pay the money. Okay. More pays jointly, or it may be made payable in the alternative to one or two, or one or some of several pays. So pay here is the person who will pay the money. Okay. Then come to the provisions noted are subject to section 31 of the Reserve Bank of India Act 134. What does it provides? You see, as per the negotiable instrument, no person in India other than the RBI or the central government can make issue a promissory note payable to the bearer. Okay, so no other person can make a promissory note other than RBI and central government. Okay. Then next is that no person in India other than the RBI or the central government can draw or accept a bill of exchange payable to bearer on demand. Okay, another condition. Then as per the rule of check, a check payable to a bearer on demand can be drawn on a person's account with a banker. So it is for everybody, okay, except the promissory note and bills of exchange. So this is applicable, that is implication of the provision of section 31 of RBI Act are no matter whether a promissory note is payable on demand or after a certain duration, it can never be originally made payable to the bearer. Okay. Then a bill of exchange can be made originally payable to bearer, one who is the bearer, the drawer. Okay. But if it is payable to bearer, it cannot be made payable on demand. Can be made payable only to order. That means whichever date is mentioned, that the payment can be made. So that it cannot be made. Okay. It can be transferable. Before the maturity date, it can be transferable, but payment will be made before the maturity date. Okay. So here some definitions. Usually notice given here. Okay. Now here it is a format or a specimen of promissory note. How it is written here. Suppose S. Gupta has promised. Okay, S. Gupta here is the promiser who will promise to pay some money. Okay, here is a format of promissory note. This is of bills of exchange. How it is given. So bills of exchange paid by the seller. Okay, it is the drawer or the seller. That is the maker. Then this is the check. Have seen the specimen of check. Everybody check. Now come to essentials of instrument. What are the essentials? So here first essential characteristics is it is essential for the negotiability of instrument that it should be expressed to payable to order or bearer or some other equivalent should be paying to assign or transfer the same third person. Okay, in such a way it should be created or it should be made that it should be transferable to other party or third party or third person. Hence, an instrument must be made or must be made or drawn payable one of the following forms. Okay. Order, ordered. How order will be made? It should be mentioned to A. Okay, some person or two individuals. It is not necessary that the form 2 should be. Another word can be used that is the of written in this. Then next essential is it is already stated that a negotiable instrument means promissory note, bills of or check payable either to order or to bearer. Payable to order when it is expressed to be so payable and also when it is payable to a particular person and does not contain words prohibiting transfer or indicating an that it shall not be transferable. So now, here you see transferable word is repeated why because every time any there should not contain a word which will restrict the word of transfer. And the instrument can be transferable. Such thing cannot be transferred. Okay. So then next is according to check. Okay. Here one cross check is there.
Ma'am, you're not audible. We can't hear you.
I think I have some network problem because everything is okay. I think maybe some my network is disturbance. My mic is on. I think. Let me see. Is it not totally not audible or it is some disconnect is there? Disconnect. Yes. Yes. Someone was saying that I'm not audible. Is it audible now? Yes.
Uh, Ma'am, it's audible, but the sound is very low.
Am I audible now?
Yes, ma'am.
Ha. Okay. Let's continue then. Okay. Hmm. So next is now when a promissory note, about the promissory note, a bill of exchange or check is transferred to any person so as to execute, so, sorry, constitute that person the holder, therefore the instrument is said to be negotiable. Okay, so it is transferred as per the section 14 of the promissory note, and according to section 15, when the maker or holder of a negotiable instrument signs the same, otherwise than as such maker for the purpose of negotiations, on the back or face thereof, or on a slip of paper annexed thereto, or so signs, that is signature signs for the same purpose, a stamped paper intended to be completed as a negotiable instrument, he is said to endorse the same and is called endorser. So that means when a negotiable instrument is transferred, so there is a signature and there it is mentioned that who will negotiate to whom. Okay. Then next part is, that is presumptions about negotiable instruments. So some presumptions are there. First one, that is consideration. Okay. So every instrument which is made was made and drawn, accepted, endorsed or transferred for consideration. That means consideration here means for money. Okay. Then date should be mentioned, time of acceptance should be mentioned. Now here you see, time of acceptance is important for the bills of exchange. Unless and until one bill is accepted by the drawee, okay, drawee, it is not, it is not enforced. Okay, if suppose bill is drawn on 20th of a particular month, suppose July, 20th July, if suppose any bill is drawn, but it is accepted on 25th July. So here the maturity date will be counted from the 25th July, not from the 20th July. Okay, so time of acceptance is important for calculating the maturity date. Then time of transfer, at which time it can be transferred. So every transfer of a negotiable instrument was made before its maturity. So whichever whichever instrument is to be transferred, it should be transferred before the maturity date. After the maturity date, it is not used. It is not of any use because okay. Then order of endorsement. So endorsement here it is transferred. So endorsement appearing upon a negotiable instrument were made in the order in which they appear thereon. Okay, it is in the same way according to the order. Duly stamped, obviously it is a valid one, so it should be stamped one. Okay, then who is the holder? So holder of a negotiable instrument is also a holder in due course. That means during the course of maturity date, before the maturity date. So long as it not proved that the holder has obtained the instrument from its lawful owner by committing an offense, that is fraud, or for unlawful consideration. Okay, so here there should be a legal way to transfer a negotiable instrument. Okay, it should not be unlawful, it should not be in a fraud case. Then protest, what is that? In a suit upon an instrument, if suppose some dishonor case is there or it in a case of fraud, okay, the court shall presume the fact of dishonor on proof of the protest. Okay, if it is dishonored like check, if it is bounced, so here the holder of the instrument can protest in the court of law. Okay, then there is ambiguous instruments are there. Okay, ambiguous instrument, what is that you see? So an instrument which in form or terms is such that it may either be treated as bills of exchange or as promissory note is an ambiguous instrument. So according to section 17, where an instrument may be constructed either as a promissory note or bill of exchange, the holder may, at his election, treat it as either, and the instrument shall henceforth treated accordingly. Okay, that means the holder, at the intention of holder, it can be treated as ambiguous instrument. So here it is how it is taken. So where drawer and drawee are the same person. Okay, if drawer and drawee are the same person, and where drawee is a fictitious person, that means drawee is a fictitious person, here drawee and drawee are the same person who will receive the cash or who will receive the money. Okay, then when drawee is a person incapable of entering into a contract, in that case it should be treated as ambiguous instrument. Okay, so then come to in quote instrument, that is, what is that you see? It is a, the term in quote instrument means an incomplete instrument. A negotiable instrument properly stamped and signed but blank or incomplete in some respect is known as in quote instrument. Okay, then sometimes in business what happens, sometimes person may sign on a blank stamp papers to be afterwards duly filled up. Okay, so sometimes in business some blank instruments are also there, so that is called input instrument. Okay, so then next you see capacity and liabilities of various parties. So there are various parties. First, you should know who are the parties in bills of exchange and promissory note. So in case of bills of exchange, there are drawee and drawee, where in many cases, drawer and drawee are the same person. Okay. So the one who will draw the bill, okay, draw the bill to pay money, then payee, the person named in the instrument to whom or to whose order the money is directed to be paid by the instrument, then endorser and endorsee, when the holder transfers or endorses the instrument to someone else. The holder is called endorser and the person to whom it is endorsed, it is called endorsee. And the holder, the person who is legally entitled to possession of the negotiable instrument in his own name or to receive the amount. Okay, holder can be the holder can be anyone, the drawer or the instrument to whom it is transferred. Okay, and whoever is the ultimate holder will receive the money. Okay, then in promissory note, maker is the one party, that is the person who who promises to pay the amount. Okay, then pay, the person to whom the amount of promissory note is payable. Then holder, either the payee or the person to whom the promissory note might have been endorsed. Then parties to check, drawer and drawee and pay. That's all. Okay. Then competence of a person to be a party to a negotiable instrument. That means which person is competent or which person can create a negotiable instrument, who has the capacity. Okay. So there are some person, that is, first of all, here incapacity, the one who has incapacity to regard as to make as negotiable instrument, that is minor. Okay, obviously minor may draw according to section 26. Here it is given, certain exceptions are given. Here in case of minor, what happens, you see, according to section 26, a minor may draw, endorse, deliver and negotiate a negotiable instrument so as to hold all parties except himself. Okay, so except himself, he can include all the parties liable. Okay, so the minor cannot bind himself by drawing, endorsing, delivering, and negotiating an instrument, and the instrument will be valid and binding on all parties except the minor. So, minor is not considered here in negotiable instrument. Okay, then partnership firm. In case of partnership firm, the partner of a trading firm had an implied authority to draw, accept and negotiate negotiable instrument. Okay, but there is a certain case, but in case of non-trading firm, a partner cannot do so unless he has an express authority to that effect. Okay, so in both the cases, however, liability must be incurred in the name of firm. Both cases, whether it is a trading or non-trading firm, both name of the firm so as to bind all the partners of the firm. Then in case of insolvent, so insolvent does not have the contractual capacity to draw or make, accept, endorse any negotiable instrument, okay, which would make his estate liable. That means obviously already a person has become insolvent. Okay, so he or she cannot make or draw a negotiable instrument. He or she can, however, validly endorse an instrument of which he is the payee or endorsee to a holder in due course. Okay, if suppose some instrument is transferred to insolvent, in that case it can be endorsed to some other person. Okay, then agents are there. A person who is competent to make, draw, or accept a negotiable instrument himself may also do through an agent also. Okay, so an agent can execute a negotiable instrument so as to bind the principal only in the capacity for which he has been specially and expressly authorized. Unless and until agent is authorized, the agent is not liable to draw or accept a negotiable instrument. Okay. Then in case of company, basically joint stock company or a corporation can be a party to negotiable instrument if it is authorized so by its memorandum or articles of association, if it is mentioned in the agreement. Okay. However, a trading joint stock company has an implied power to draw only for the trading company. Okay. Power to draw, accept or negotiate negotiable instrument. Then in case of legal representatives. Okay. So legal representative of a deceased person, the person who has already died. Okay. In that case, can deal with the negotiable instrument belonging to the deceased to the extent as the deceased could have done, only to the extent which the deceased person could have done, only to that extent. Okay. So there can be a limited liability. Liability can be limited, okay, to the extent of asset inherited by him from the deceased. Then alien enemies, okay, the foreigners. So an alien enemy is a person who is resident in a country with which the government has declared war. Okay, so alien enemy means the person who belongs to that country in which the government has declared a war, like for example that China, that can be called as alien enemy. Okay, a bill drawn to or endorsed by an alien enemy cannot be enforced even after peace is concluded. Okay, it cannot be accepted. There are certain exceptions are there, which is to be explained in a that is in other way also. Okay, liability of various parties. So what are the liabilities you see? Liabilities of the parties are there. Suppose in minor, so by in case of minor does not create a legal contract. Okay, so simply it is void. Nothing, no liability of a minor. Then in case of lunatic, okay, it is in case of lunatic, that means the person of insane mind. Okay, the person who has no sane. So in it is same case as minor. And in case of married woman, married woman can enter into contract. Okay, then insolvent. So insolvent, entire property including bills of exchange, promissory note, other negotiable instruments pass to the official assignee or official receiver. It is passed to that person. Then same for agents, legal representatives of a deceased persons, then holder of a promissory note or bills of exchange, who are the holders. Okay, then holder in due course, who are those, let's see, sorry, so holder in due course, only I am explaining the definition here. You see, according to section 9, who is holder in due course. So holder in due course as any person who for consideration became the possessor of a promissory note, bills of exchange or check, if payable to bearer or the payee or endorsee thereof, if payable to order before the amount mentioned in it become payable and without having sufficient cause to believe that any defect existed in the title of the person from he is derived. That means at present, who has the promissory note or bills of exchange or check, that means holder in due course. So some essential qualifications of holder in due courses are given here. Go through it. Then privileges, what are the facilities or benefits of a holder in due course is there. So here one example is given, that is, if suppose A, the holder of a bill, endorses it to B, it is transferred to B, who is a minor. So here B is a minor, therefore cannot be made liable. The bill is stolen from B by C, who forges B's endorsement and
sells the bill to D for value. So by fraudulent act, C what has done? He has stolen the bill from B and again he has endorsed or sell the bill to D. Now, D is a holder in due course and is entitled to sue A. Okay. Even if there is a fraudulent case, then also D is liable for entitled for the money. D can sue to A and all parties prior to A, such as the drawer, the acceptor, and all prior endorsees. Okay, D can sue all the parties to B also, who has accepted, and C also, who has stolen also. He can also sue, but not B. Sorry, B is not liable for this sue. Okay, but not B. This means that D holds the bill free from the defect in title caused by C's theft and forgery. Okay, so D is holding the bill which is free from the forgery or free from the illegal act by the C. So D is liable for the payment. Okay. So this is holder in due course. In whichever situation, the bill is being transferred to endorsee. Then, sorry, the next part is that one unit I have skipped here, which was not able to download it. That is about the bills of exchange and promissory note. Okay, so only the audio was there. So if you want to hear it, you can go through eGyan course and there you will get that part. Okay, the same thing is explained, that is bills of exchange and about the promissory note. So in this next part, that is negotiations, how it is transferred. Okay, it is explained here how it can be transferred and how it is different, or say what is the similarities between negotiation and assignment. Okay, so the ownership of negotiable instrument sorry, can be transferred in two ways, by negotiation or by assignment. Okay, so although negotiation and assignment result in the transfer of a right or ownership, these two terms are different. They are different in some sense. Okay, so negotiation means transfer of an instrument from one person to another so as to constitute that person the holder of the instrument. Okay, so to whoever it is transferred, now ultimately the holder in due course, just an example, whoever will hold the bills of exchange, that is the ultimate holder of the bill. Okay, then in case of assignment, it means transfer of ownership of a negotiable instrument of a written and registered document under the provisions of the Transfer of Property Act. So as per the Transfer of Property Act only, the assignment can be transferred. Okay. So Transfer of Property Act, usually it is in case of immovable property. Okay. In case of sale of good, you might be remembering there is only for movable good, and for immovable good there was a act of Transfer of Property Act. Okay. So in order to be negotiable, an instrument should satisfy two conditions. That is, it must be in a form which is recognized by law for being sued upon by the holder. Okay, if suppose in case of any fraudulent case or any illegal act, the holder can sue. Okay, it should be identified by the law. Then only it is transferable. Then it must be transferable by custom of trade. Okay, there is certain law for that. Then modes of negotiation, how it is transferred or how it is negotiated. First one is delivery, then next is endorsement. Okay, so delivery according to section 47, subject to the provisions of section 58, a promissory note or bill of exchange or check payable to bearer is negotiable by delivery. Therefore, in case exception is there, a promissory note, bill of exchange or check delivered on condition that it is not to take effect in a certain event is not negotiable except in the hands of a holder for value without notice of the condition unless such event happens. Okay. Then some examples are here, you see. That is, if A, the holder of a negotiable instrument payable to bearer, delivers it to B's agent to keep it for B, the instrument has been negotiated. Okay, here in this example, agent of B is now holder in due course because B has assigned his or her agent. Okay, so now here holder in due course is the agent, not B. Okay, then instrument payable to bearer as per the section 47 deals with the negotiation of an instrument payable to bearer. Okay, it is payable to the bearer of the instrument. Similarly, 47 as section 47 is explaining other things also, you can go through it. Then position of a transferor by delivery. So what is the position of a transferor, who will the one who is transferring the instrument? Then endorsement, again it is a type of, that is transferring the instrument. So here you can see that some points are given in which condition or in which situation it can be negotiated. Go through it. Kinds of endorsements are there: endorsement in blank, endorsement in full. These all are about how it is transferred or how it is negotiated. Then there is a restrictive endorsement also. Okay. Then partial endorsement, conditional endorsement. Okay. Go through it. Only the basic part I am explaining, others you can learn. Okay. Then negotiation back, it is again, it is back to transferred back to the drawer or the bearer. Okay. Then liability of various parties. In many cases, some liabilities occurs or expenses occurs which is payable by some parties. Okay. So liability of the drawer of a bill, in which cases liability is payable by the drawer. Okay. Then liability of the drawee of a check. In this case, that is liability of banker is also there for wrongful payment of checks. Then liability of banker to holder, checks sent for realization, duty of banker regarding bills, compensation for dishonoring of a check. Okay. Then liability of the maker of a note and acceptor of a bill. So here liability of a maker of a promissory note, drawee not liable until acceptance, liability of an acceptor, then distinction between liability of drawer, acceptor and maker, then parties to whom it can be sued, liability of endorsers are there, liability of prior parties to holder due in course. Okay. Then if suppose instrument is lost or stolen, for that some criterias are given under various sections. Okay. Then if suppose instrument obtained by a fraud person, what he or she can do in that condition, what are the criterias? Then forged instruments or forged endorsement. Forged means it is just making a wrongful act. Okay, just editing in a wrongful way. Okay. Then last part, that is pre-settlement, settlement and discharge. It is nothing but it is placing the negotiable instrument before a drawee. Okay. Presentment is done for the after acceptance, for sight and for payment. Okay. How it is presented. It is the rules and regulation for the presentment of for acceptance. Okay, in which condition it is accepted, who can make the instrument, okay, at which time it can be presented, and effects of, if suppose on the maturity date, if suppose bill is not able to be presented, in that condition what is the effect. Okay, then place of presentment, what is the proof of presentment, if suppose in case of promissory note payable to a certain period after sight. Okay, then types of acceptance are there. So all these are there, go through it. Then come to presentment for payment, at which time a bill or a instrument can be presented for payment, okay, to whom, and if suppose if it is not presented, what will be the effect, waiver of presentment. All these points are there, this you can read. Okay, and suppose if suppose check is bounced or promissory note or bills of exchange is dishonored, in that case what is the effect, what is the impact, in which cases it can be dishonored. Okay, and by non-acceptance also it can be dishonored, bills of exchange. Okay, dishonor by non-payment is there, rules are there. Rules particularly focus on the rules. Okay, rules and essentials. So then noting and protesting are also there, some short points are there. Then discharge from liability, how you can, it is discharged from the liability, how liability is not payable in various cases. Then effect of material alteration, if suppose materials are alterated, okay, changed, some meaning is also there, go through that. So this is the about the business law. So there is one question, you might have already seen how question pattern is given. Okay, so this is the term and examination of December session, December exam. In this way question comes, it is of 2 hours, that is of 50 marks. Okay, so in this way question will come, you have to answer any 5 questions. Okay, all are here, you can see that every question, in suppose question number 1, define contract and what are the essentials of a valid contract, if suppose it is given. So here it is 2 part of the question. So here marking is also clearly mentioned that first part carries 2 marks. That means answer only for 2 marks, not a lengthy one or not an essay type. Okay. So as per the mark of the question, answer only that, not excess, not less. Okay. So every question you can see, wherever 3 parts of questions are there, answer according to the markings, not unnecessary things. Okay. So second question you can see 3 parts are there. That means 3 part means first you will answer for 3 marks, who is a minor. For 3 marks you assume that that is presume that how much it will carry 3 marks. Okay. So it is the high standard. So write exact words, exact statement, content should be clear. Okay. So who is the minor? That means 3 marks it is there. So 3 marks answer you will give, not for 10 marks. Okay. Then when is a minor liable for contract? Again 3 marks. So 3 marks answer you will give. Then here you can see third part, if a minor misrepresents his age, what is the legal effect? 4 marks. So just little bit lengthier than the before answers. Okay. So in this way question and their marking is separated. So answer accordingly. Okay. Here you can see direct questions are given, no indirect question is given. And as I was telling that some examples will be given and you have to explain the condition, the reason. Okay, so here in question number 9 you can see some examples are there. Some examples are given and you have to give reason for the answer. Okay, suppose for example question number 9 bit A hires a car from B, the car is unsafe, though the owner B is not aware of it and A is injured, is B responsible for A for injury? Okay, here condition is not fulfilled. What was the purpose? The purpose was that to say that car should be hired by the B. Okay, so go through it. You can solve it. Okay, for Hindi student, those who can't understand for English, they can answer in Hindi also. As I'm not able to explain in Hindi some words of so it will be a mixed match. So that's why I'm explaining in English. Okay. If you have any doubt for this question pattern or any, you can contact your coordinator. Okay. Time and terms of the examinations, you can contact to the center, study center. Okay. Okay. Let us end the class. Okay. Thank you.
रमेश भाई, क्लास को बहुत जल्दी आए आप।